What to say at an early resolution meeting. Many of my clients have reported to me that they've attempted to conduct an early resolution meeting and they did not know what to say. I'm going to tell you what to say and what may have value. But I'd like to first say that, the way my firm or anyone from my firm or even myself, the way we would approach an early resolution meeting is going to be significantly different from sort of the average member of the public out there. So the best way to describe what to say is, I guess I can start with what would not be of any value if you did say it. Okay, so let's say you have a piece of paper, it's come in the mail or it's been emailed to you, and it gives you a date and it says, usually there's a couple of letters, like an acronym, ER, early resolution, and that gives you a date. And in Ontario these days, usually that's done by a phone call for most people. If you have the ability to sit at your computer in front of a camera, you can do it in camera. And what will be happening in those situations is you're going to meet directly with one of the prosecutors involved. Now, you're going to be either going to be one of two things that you're going to be dealing with. And if you review the other videos that I posted, you'll understand the difference between a strict liability offense, an absolute liability offense. Okay? And it's important to know the difference if you're attending one of these ER meetings. Best example I can provide you at this point in time with respect to what you'd want to say is, let's consider a speeding ticket. It's probably the most common thing that people are going to attempt to deal with on their own. In a situation like that, there are all kinds of things that go through the mind of someone that's charged, and they have this desire to tell that prosecutor in that meeting about it, with the goal that, they're going to withdraw the charge or they're going to do something about what's happened here. And oftentimes you're going to hear clients that potentially are going to say, well, hey, my speedometer was broken at that time. Or I had to go to the bathroom, of all things. And in their mind, they're thinking, well, I'm just going to simply tell that to the prosecutor, and that's going to get me where I need to be, whether that's going to be the withdrawal of the charge or it's going to be reduced. And what I know from those types of meetings and those types of charges, so absolute liability, speeding, before you even arrive at that meeting, before you even attempt to say anything, usually the prosecutor's already got a position in mind, whether that I'm not going to do anything for this person at all, or it could be, well, I'm going to offer them some sort of a reduction. So the reality in a situation like that, as you conduct your ER meeting and as you present what you think you should be telling them, it's already been pre-decided. And if not, some of the things or most of the things that you say in that offense regime of absolute liability have no impact anyway. So the reality is that it's going to be most unproductive. And oftentimes I find, over the many years I've been doing this, clients are very disappointed in that sort of a situation. The same is true if the other end of the continuum is something like a careless driving, also very common. And clients will tend to go in on their own and try to deal with it, and they want to know what to say to achieve the result they want. Most people want the charge withdrawn. And most people, if not withdrawn, they want it reduced to something that is going to work better for them in their lives. And there are certain things that you can say that would potentially help you in a situation like that. But there are many more things that you could say that can make the situation worse. Now, I've already told you that when you enter those meetings, most of the time, the prosecutor's already made up their mind. And of late, I've seen in these ER meetings where prosecutors have even sent out the material in advance. So you have not said a word, you haven't spoken to anybody, you certainly haven't spoke to the prosecutor, yet you've received the Crown's position or the prosecutor's position before you even attended. In those situations, particularly when you're representing yourself, it's virtually impossible for me to tell you what to say in order to fix that. you've already got the result that you're going to get, and that's as best as it's going to get. These situations are always, I'm going to tell you, I always have a sigh about, oh boy, because I'm slightly disappointed that we didn't have that opportunity to do that meeting for you, because we do know what to say and we do know the context, whether it's absolute liability or whether it's strict liability, important things. The way in which those ER meetings are conducted with someone like myself is very different than an unrepresented person. So to answer the question fully on what to say, I would suggest you review the other videos so you know the difference, and you need to understand that there are many things that are, when you say to the prosecutor, you may just simply annoy them, which may frustrate them to the point where this person, I want to earmark, and that's a trial that I want to conduct because you've annoyed the prosecutor, okay? These types of things you want to be super aware of before you enter that meeting. And remember that if you're considering getting help from a licensed lawyer or paralegal, it is always better, and I appreciate this is self-serving, but it is always better if you approach us first and allow someone who does this on a regular basis conduct that meeting for you. That would put you in a position of the most advantage. Thank you for taking the time today to watch our video. We are dedicated in providing you the information that you will need to make a good decision. If you are in need of a free consultation, please take the time to contact us.